The Supreme Court today delivered a split verdict in the Karnataka hijab ban case. That's our big focus story. Let's tell you more details about this. Now, in view of the divergence in opinion, the Apex Court has now directed the matter to be placed before the Chief Justice of India for appropriate direction. So what were the grounds cited by Justice Hemant Gupta and Justice Sudhanshu Dhulia? Let's put that out on our screens. On the observations made by Justice Gupta, who dismissed the appeals challenging the Karnataka High Court order, while Justice Dhulia allowed them. So quickly, let's go through the highlights of what the two judges observed and see the divergence of views. If we can put that out on our screens, please. Let's look at Justice Dhulia's observation first. So Justice Dhulia says that probably the High Court took a wrong path. It was simply a question of Article 19 and Article 25, freedom of expression versus right to practice of religion. Ultimately, a matter of choice, nothing more, nothing less. Uppermost on my mind was education of a girl child. In fact, those are the observations made by Justice Dhulia, who seems to be pro-choice and against the ban. Let's now look at the questions considered by Justice Gupta. If we can change the graphics to Justice Gupta, what he said is these are the questions that he considered before giving out his verdict. Can a college take a call on uniform? Is hijab violating Article 25? Are Article 19 and Article 25 mutually exclusive? Does the government order violate fundamental rights? So Justice Gupta clearly makes it about violation of fundamental right and whether that is a case that can be made here. Can a student exert fundamental right? Is it part of essential religious practice? Does the government order serve the purpose of education? These are the questions that Justice Gupta says were considered, and it went against the petitioners. So that's the crux of the matter. Let's welcome here, joining us on the program, Senior Counsel of the Supreme Court, Majid Menon. Thank you very much, sir. Very good evening to you. You know, it's very clear that the court goes by the book. It has invoked right to religion, right to freedom of expression, and the question of fundamental right. Mr. Menon, will the matter then ultimately be settled wholly and solely on whether it infringes on a fundamental right?
Well, this issue has several ramifications in as much as this is not purely a religious issue. It's an issue which can be considered as a social or a matter of choice of the students, and also it is a kind of a clash of rights between individual students on one side and the institution, the educational institutions and the government. Now, if it is argued, as has been happening, we are hearing in Karnataka High Court or even in Supreme Court, it is argued that, well, wearing of hijab is not compulsory for Muslim girls and it is not a Quranic mandate. Well, this argument will not be sustained for the reason that even assuming that a Muslim girl is not under an obligation to necessarily put on hijab at all times, it is her choice. And the right to choice, as rightly pointed out by one of the two learned judges, Justice Dhulia, that the right to choice does
liberty,
exist.
sir, because it will clash with the concept of uniform then. Then it will come down to the issue of uniform. Yes.
Just give me one more minute. See, I wanted to explain that if there is conflict between the right of the educational institution to impose discipline and to frame rules, it may be on one side, as against the right of students to dress of their choice and to exercise their right in respect of their attire. Well, there has to be a kind of a compromise between the two. You see, no right either of an institution or an individual can ever be absolute. All rights are subject to reasonable restrictions, and therefore the educational institution's right to impose such kind of rigid terms with regard to the attire of these girl students, and on the other side, the girls claim that they would want to have also is subject to reasonable restrictions. And I think the Supreme Court will find a via media and come out with. But before, I would also want to tell your viewers that
Yes.
it is not just Karnataka. Throughout the country, the girls are going to the schools and Muslim girls are going with hijab. Now, the dispute or the controversy has arisen only in one state, that is BJP ruled state. Now, I think Parliament should be made to settle this issue by considered discussion among the members of the Parliament, and also some parliamentary standing committees on law and justice, or parliamentary standing committee on education, or parliamentary committee on home. You see, these committees can very well go into the depth of the matter and formulate some kind of a rule which should uniformly be applied throughout the country, because Karnataka is just one part of the
Yes.
whole of India.
So will this verdict then, once the larger bench decides, will it have implications for the country-wide, implications? Will it then apply everywhere? Is that what you're saying?
No, Supreme Court certainly, with its wisdom, is going to ultimately set at rest the issue which has now brought to us to a state of split verdict. Of course, that's a duty of the court, that whenever there is a split verdict, a larger bench is constituted, and then the majority judgment or the unanimous judgment will be operative. And that, of course, in the due course of time will happen. But my only anxiety is that the problem has arisen only in state of Karnataka.
So this is important, what you're saying, right. Two very important points you made. In fact, this was a question that I wanted to ask you, which you've already answered, that even if, the question is about whether this is integral to the practice of Islam, you are saying that would become irrelevant, because even if it was integral or was not integral, it is still a matter of choice. It would still remain a matter of choice for a woman, and no freedom can be absolute, whether it is of the hijab wearing girl or for the institution to impose uniformity. The other question that becomes very important here is, you are saying you are of the opinion that Parliament should decide, are we becoming that kind of an intolerant society? Is it then a question of religious tolerance? Until yesterday, hijab was not a problem. Today it is. And you're referring to the fact that this is a BJP ruled state. Are you saying that there are vested interests deliberately stoking this fire? Mr. Menon?
Yeah, I'm sorry, I just lost your voice. In any case, let me tell you that there has to be a kind of a compromise in the conflicting rights and powers of institutions and individual students. Now, Justice Dhulia has, it seems, answered a few such questions, in as much as he has said that it is not merely a religious right, it is the right of choice. And unless it, conflicts with the discipline of the school or the policy of uniform, it certainly has to be allowed. Of course, if it clashes with the rule of uniform, that the girls want to say that we won't wear a uniform, then definitely the girls would be wrong and the institution would be right. And what we are expecting is that if a midway is to be found out, which I am sure even the Supreme Court is competent enough to uphold the rights of both sides and protect them for the purposes of implementation of the practice hereafter.
Yes, but what would you say to those who believe that wearing a hijab is after all a regressive practice, and as a society we need to do away with it, just like we did away with sati or dowry or triple talaq for that matter? What would you say to those who are making that argument? Mr. Menon, can you hear me clearly?
No, I didn't get you.
No, I was asking you that there are those who say that after all, wearing a hijab, wearing a veil is a regressive practice. In fact, I want to put that graphics out, a number of countries that have banned the use of a face veil. So what would you say to those who are making this argument that it is a regressive practice, it's an anti-women practice, it should in any case be done away with, just like we did away with sati or dowry or triple talaq for that matter?
No, no. See, let us not compare this particular controversy with any other religious issue. You see, we may have some religious issues which may be controversial, but if this particular right of a girl, Indian girl, I would not say Muslim girl, I would say right of an Indian girl to receive education is equally important. And if you create any impediment in her receipt of education, you are violating a very important right. And therefore, as Justice Dulia has rightly said, that right to choice as well as right to receive education are important rights which cannot simply be deprived. And if it is deprived by certain rules made by certain institutions like education institutions, schools, or colleges, then certainly the courts would intervene and rescue the people whose rights are violated.
Okay. Majid, Menon, thank you so much for joining us on this subject. We go enlightened with your views on this. And of course, this is important to understand that on one hand, this is a split verdict, of course. One hand, Justice Dhulia says freedom of choice, the choice, pro-choice is what he has weighed in with, saying ultimately individual choice is paramount, whereas the other side believes that there cannot be different rules for a same set of people. Uniformity is paramount. Rules of a school would be the same for everyone, and there cannot be preferential treatment for one community. So these are our